She said, Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this mandamus action. So I wonder if the reason that Brian Steele is saying that he is counseling, or or Judge Glanville is on the team or on the same team as Miss Hilton and Miss Love, is because of this statement right here made by Judge Krauss. In addition to Judge Rachel Krauss denying that motion to recuse herself from Brian Steele, she actually responded to what Yak Gotti's lawyer was saying, which was Mr. Weinstein. When he sent his entire writ of mandamus to the Supreme Court, you guys might remember, he said, hey, everybody who's involved in Fulton County, I want to get them out of here. I don't want anybody who's in Fulton County covering this case. I don't want them covering any of these recusals. I think it should go somewhere else. Well, now I guess Judge Krauss, she is on top of it. She actually responded to what Yak Gotti's lawyer said in this motion here. OK, and this denial, basically, she says, order denying motion to disqualify Fulton County Superior Court judges from ruling on recusal of Chief Judge Glanville. All right. And what does Rachel say? Or what does the Honorable Judge Rachel Krauss say? She says, this case was randomly assigned to this court to consider certain motions to recuse Judge Glanville from further proceedings in this case. On July 2nd, 2024, defendants DeMonte Kendrick, aka Yak Gotti, filed a motion to disqualify Fulton County Superior Court judges from ruling on recusal motion of Chief Judge Glanville. All right. A motion to recuse must be timely and accompanied by an affidavit stating the facts and reasons that bias exists and recusal is necessary. Now, again, in Judge Krauss's defense, there really, thinking about it now, there really wasn't anything in his recusal that said specifically that Judge Rachel Krauss shouldn't be on this case. I mean, other than the fact that she was just in Fulton County, she even states this was randomly assigned. We already saw Belinda, who worked closely with Judge Glanville for over 7 years. She recused herself. She didn't even want to cover this case. And then it was sent to Rachel. So I'm kind of with her on this one. I don't know where I'm seeing that she could be removed just because she's in Fulton County. From a legal standpoint, anyway. A motion to recuse must be timely and accompanied by an affidavit stating the facts and reasons that bias exists and recusal is necessary. Importantly, allegations consisting of bare conclusions and opinions shall not be legally sufficient to support the motion or warrant further proceedings. And that's kind of what we just talked about here. When a judge assigned to a case is presented with a recusal motion and accompanying affidavit, we just read this in the past one, it says the judge shall temporarily cease to act upon the merits of the matter and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if provided, would warrant the assigned judge's recusal from the case. If all three criteria are met, another judge shall be assigned to hear the motion to recuse. And we just talked about, I don't know if I'm seeing it here. It's probably a little bit of a stretch by Yak Gotti's lawyer, but we'll see what she says. Assessing whether these three criteria are met does not involve an exercise of discretion by the judge whose recusal is sought, namely Judge Krauss, right? But is a question of law to determine by the assigned judge. Okay, see Mayor and Alderman of the city of Savannah versus Boston or Batson Cook, excuse me. Assuming without deciding that Yak Gotti's motion is timely, it is not supported by an affidavit of any kind. Yeah, and that's where they kind of messed up. He didn't really show, hey, this is why you need to get every single judge who's in Fulton County out of here. That's going to be a tough one, right? As required by Rule 25.1. Therefore, the motion is due to be denied. See Huff versus State. The trial court properly denied a motion for recusal unsupported by an affidavit required by USCR 25.5 and 25.2. Yeah, so Mr. Weinstein didn't do his job all the way is what she's saying. Defendant Kendrick's assertion that Judicial Qualification Commission Opinion 220 requires recusal of the entire Fulton Superior Court bench does not save the unsupported motion. In opinion 220, the JQC opined that it is inappropriate for any trial court judge to preside in any action wherein one of the parties holds a judicial office on the same or any other court which sits in the same circuit. But Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this a mandamus action. And defendant Yak Gotti cannot make it so by filing a recusal motion. Okay, and then they have a note here, which we talked about in the past, but I want to go back and read this for a second because this part's interesting. She says, Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this mandamus action. So I wonder if the reason that Brian Steele is saying that he is counseling or or Judge Glanville is on the team or on the same team as Miss Hilton and Miss Love is because of this statement right here made by Judge Krauss, right? Because in order for Judge Glanville to be out of here, he would clearly have to be a party or a counsel in this criminal prosecution. But by Brian calling him out and saying, hey, look, this is how I'm showing that they're on the same team, then maybe he might have a case here. Again, this is me just looking at it not as a legal professional, but just something I see here that would be an interesting connection is maybe why he's pushing so hard to paint Judge Glanville as being on the same team as the prosecution, which is interesting. In opinion 220, the JQC opined that it is inappropriate for any trial court judge to preside in any action wherein one of the parties holds a judicial office on the same or any other court which sits in the same circuit. But Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this a mandamus action. And defendant Yak Gotti cannot make it so by filing a recusal motion. All right, compare Georgia Transmission Court v. Dixon, where judges were either parties or counsel in the underlying civil case being heard by a judge in the same circuit. Okay. Furthermore, defendant Yak Gotti's motion ignores the clear derivative of Uniform Superior Court Rule 25.4. The rule directs that in a multi-judge circuit like the Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made using the circuit's existing random impartial case assignment method, which we just talked about, right? Defendant Yak Gotti's motion to disqualify the Fulton County Superior Court judges from ruling on recusal of Chief Judge Glanville lacks an affidavit and fails to satisfy the requirement of 25.1 and 25.2. Yeah, that makes sense. Yak Gotti asserted basis for recusal, even if supported by an affidavit, would not warrant recusal in light of USCR 25.4. So I was looking at this. I was wondering, okay, if say in theory, Mr. Weinstein goes back, he writes an affidavit, he finds that, you know, the $2,000, he puts that in there. Judge Glanville donated $2,000 to Judge Krauss, right? And then he finds something else. They've been golfing every Saturday for the past 10 years. And now he finds that, I don't know, she's been showing him favorable rulings when he was an attorney. All right, something crazy like that, right? If he goes back and adds an affidavit to his motion, and then he goes through the process again, I was thinking, well, maybe that would be enough for him to try and get Rachel Krauss removed. But she's saying here that, and let's read this again, that Yak Gotti's motion to disqualify the Fulton County Superior Court judges, and he's talking about all judges, from ruling on recusal of Chief Judge Glanville, lacks an affidavit, and fails to satisfy requirements of 25.5 and 25.2. And also, the asserted basis for recusal, even if supported by an affidavit, would not warrant recusal in light of 25.4. So basically saying whatever you do, you're not going to have a chance. It's not going to happen. She says, therefore, the motion is hereby denied. It is so ordered this the 9th day of July 2024. Hey, Rachel was putting in some work now. Shout out to the Honorable Judge Rachel Krauss out here just shutting the defense down. Now, there's still a couple other recusals out there, not necessarily against Rachel Krauss, but obviously there is a deadline today that the state needs to meet, and they need to respond and say, hey, what are y'all going to do about these recusals? Are you going to continue to go? We're going to take the next step, or are you going to get up out of here? So it's going to be interesting to see if what we know of Judge Glanville and, of course, ADA Hilton and ADA Love, that ain't happening. They're not going anywhere. So I have a feeling Judge Glanville is going to fight this to the death. But y'all let me know what you think. Was Judge Krauss right on this one? Did she make the right call? Should she stay on this recusal? Should she be able to rule on it? And what do you guys think is going to happen at the end of the day when they hopefully respond? They might get a little bit more time, but we'll see what happens here.